Okay, we made it. We made it to the end, to our third and final keynote. The one who drew the short straw to go last, to stand between you and freedom, or further conversation that will be inspired by this. So again, thank you for coming, and thank you for coming into this talk in particular. Our final speaker is Jonathan Gienapp. Jonathan Gienapp, who is Associate Professor of History and Associate Professor of Law at Stanford University. He specializes in the constitutional, political, legal, and intellectual history of the early United States, with a focus on the origins and development of the U.S. Constitution. As we'll hear, these interests bear directly on both political and scholarly debates over constitutional theory, meaning, and interpretation. One of the threads connecting our three keynote speakers is that each has authored a paradigm-shifting work, or at least that's how I think they should be thought of. For Roger Smith, that's his work on the multiple traditions in American political development. For Maggie Blackhawk, it's her work recentering American colonialism and Native peoples in public law. And for Jonathan, it's his first book, The Second Creation, Fixing the Constitution in the Founding Era, which reorients how we think about what kind of thing the Constitution was, and also shows how it was fundamentally shaped and reconceived in its early years. I think this book will be viewed before long, if it isn't already, as one of the truly seminal historical works on the American Constitution, one that stands alongside Gordon Wood's creation of the American Republic, Jack Rakow's original meanings, and Pauline Maier's ratification. And one other thing Jonathan has in common with Gordon Wood is that he wrote this book near the beginning of his career. So we have much more scholarship and illumination to look forward to, some of which we will hear about this afternoon. So please join me in welcoming our final speaker, Jonathan Gienapp.
Okay, well, gosh, that was quite the introduction, Connor. Thank you so much. So I feel like Connor's an old war buddy, but we've never actually met in person until yesterday, just years and years of talking via email and Twitter through common interests. So it's an extraordinary honor to be here giving the final keynote. Thanks to all of you for making it to the end. Thanks to Connor for the extraordinary invitation, to Sophie and everybody else at the Center for the Study of the United States here for everything they've done. I will try to get through my remarks as quickly as I can, because I know there is a large brigade of our distinguished guests who need to leave early to catch flights, though I leave it open to all of you to interpret what their abrupt departure might actually signal, given that so much of this talk will be on interpretation and meaning. So what I'm going to talk about today is the crisis of history in U.S. constitutional interpretation. So we spent the last 2 days pondering whether American constitutionalism is in crisis, and if so, in what ways. And this talk is in some ways an invitation to think about how the themes I'm going to talk about are in relationship with those conversations, because I think they are, but exactly in what ways is open to conversation. But one thing that is very clear is that today, American lawyers and jurists love talking about the United States constitutional history, particularly the history that I spend most of my time studying, which is the history of the founding period when the Constitution was created. We are very clearly living in the age of history when it comes to U.S. constitutional interpretation. Seemingly everywhere one turns, history is being appealed to resolve some new or ancient problem of constitutional law. Now, history has always been important to U.S. constitutional interpretation, but in recent decades, it has come to absolutely dominate the space in an unprecedented fashion. Now, that is principally owed to the rise of the theory of constitutional originalism and its core commitment that the United States Constitution should be interpreted today in accordance with its original meaning. So as definitions of what originalism stands for goes, Amy Coney Barrett's testimony in her confirmation hearing to the Supreme Court does a very good job of laying out what originalism is about and why history matters to it. So as she said, originalism maintains that the constitutional text of the United States means what it did at the time it was ratified, and that this original public meaning is authoritative. This theory, that the Constitution means what it meant back then when it was made, stands in contrast to those that would treat the Constitution's meaning as susceptible to evolution over time. So originalism was not the first theory of U.S. constitutional interpretation to emphasize history. History, as I mentioned, has always mattered to constitutional interpretation. But it was the first theory that placed such unparalleled emphasis on history, that elevated history above all other constitutional criteria and established it as the dominant determinant in constitutional decision-making. So if for others, other interpreters, history is just one interpretive modality among many, one source of legal validity among several, for originalists, history is the modality, the ultimate source of legal validity. History, or text in history, text understood through history, trumps, at least most of the time, the other kinds of criteria one might appeal to reach a constitutional decision, whether that's precedent or doctrine or consequences or longstanding practice or public opinion. What originalism does is it elevates this single criteria above the rest and establishes it as the ultimate trump card, as the source of constitutional legitimacy, the ultimate arbiter of constitutional dispute. So in other words, what originalism does is it transforms history from a resource, something you might look at, to a command, the thing that tells you what to do. In so doing, originalism creates a hierarchy of history. Not all history, not all stuff that happened before 2:30 p.m. today carries equal weight. The history that matters most is that which is most closely connected to the supreme moment of American constitutional founding. Originalism, in essence, creates a time zero in U.S. constitutional time. The founding moment when the United States Constitution was created, this marks the moment when the supreme sovereign people spoke most clearly and most resoundingly. That is the historical moment that enjoys the greatest constitutional authority. Other moments certainly matter. The Reconstruction Amendments, the so-called Second Founding, the 19th Amendment, these other moments matter, but nothing is anywhere close to time zero. Going back to the late 18th century, here this portrait capturing the Constitutional Convention that gathered in the summer of 1787 when the Constitution was written, and then in the year that followed, that Constitution was ratified by the American people, a circumscribed notion of what that people consisted of in special ratifying conventions. This is the time zero that originalism creates. So originalism has enjoyed enormous, enormous success over the last half century. First, by becoming the rallying cry of the conservative legal movement in the United States, by becoming the interpretive approach that very much bound together politicians, jurists, academics, and the various institutional networks, the Federalist Society being the most important among them, that bound these people together. But second, not only did it organize the conservative legal movement, originalism very much proved a success story in becoming the dominant frame of interpretive debate. So even if today Americans remain as divided as they ever have over what the Constitution means, to an extraordinary degree, history or appeals to the past has infused and structured that conversation. In a lot of ways, non-originalists now live in the world that originalists created. Now, that feat of coming to dominate the broader conversation required remaking the federal judiciary in the United States, which is a story that takes us back to the late 20th century when, as political conservatives began to acquire political power, they began appointing self-conscious originalists to the federal bench who would appeal to history to determine constitutional questions. So a key figure in this development was Attorney General Edwin Meese III, who was Ronald Reagan's Attorney General in the 1980s, who famously said in an American bar address on July 9th, 1985, the jurisprudence of this administration will be one of original intent. He and his team of aspiring young lawyers very much did what they could to remake the federal judiciary on originalist terms, and one of the justices that they appointed to the Supreme Court, Antonin Scalia, in 1986, was the first self-described originalist to be put on the Supreme Court, and for the next 30 years until his death in 2016 was very much the public face of originalism. But that project did not stop in the 80s. It continued on and has recently reached a crescendo. in which now the Supreme Court has a conservative supermajority of 6 justices, all of whom in one way or another would claim to be a kind of originalist. The 3 at the top, Neil Gorsuch, Clarence Thomas, and Amy Coney Barrett, true diehard originalists through and through, but more sort of casual, practical originalists is what we find with Samuel Alito, Brett Kavanaugh, and John Roberts. But the bottom line is clear. For the first time in its history, the United States Supreme Court has an originalist majority. And that majority has made it very clear that when serious questions of American constitutional law come before it, they're going to turn to history in some fashion or another to make the decision. A lot of that time, it takes the standard form of time zero history. What did the founders say? What did they think? What happened in the Constitutional Convention? What happened in ratification? But that has been accompanied as well by different ways of thinking about how we look to the distant past, which came out in the Dobbs decision, the Bruin decision, and some other decisions. This idea that to figure out other questions of constitutional law will not just require looking to time zero, but also asking ourselves what kinds of things, what kind of constitutional rights or regulations are deeply rooted in the nation's history and tradition. So this new history and tradition standard that law professors are still scrambling to try to figure out, yet another way in which the court has shown itself interested in history. Well, given its prevailing authority, non-originalists, whatever their reasons, have begun fighting on these terms as well, as we can see here from the testimony of Elena Kagan and Ketanji Brown Jackson before they were justices. Liberals who do not see themselves as originalists, but nonetheless saying things in their confirmation battle that show a willingness to engage on these terms. Elena Kagan famously saying in 2009, "We are all originalists now." And just a couple years ago, Ketanji Brown Jackson saying, "I believe that the Constitution is fixed in its meaning. I believe that it's appropriate to look at the original intent, original public meaning of the words." What exactly they were trying to do here is an open question, but what it's a clear marker of is how the terms of debate are very much based on these originalist terms. Now, these changes in the U.S. courts have also fueled, in turn, changes in legal scholarship, public discourse, and brief writing. As a historian, as a working historian, I can't seemingly escape a month without being invited to either write a historian's amicus brief to the Supreme Court or to sign on to one, as this chart by my former student, Henry Ishitani, who's now a terrific JD PhD student at Yale, recently published. He sort of measured the sort of kind of core historian's amicus brief and over time how it has dramatically increased as history has become a more dominant modality for deciding constitutional cases. You can see there Sonia Sotomayor, the other liberal justice on the court, saying that the historical amicus briefs are the most important briefs we receive these days. So what I hope this all makes very clear is that history is now king in American constitutionalism. Figuring out constitutional questions in the United States today usually means appealing to the past and usually the very, very distant past. So what is the relationship between the rise of history and constitutional interpretation and constitutional crisis? Well, I think it's complicated and needs to be understood on multiple levels. So first, there were the crises that the turn to history was meant to solve. The first of which was this sense that there was a crisis of interpretive uncertainty. The reason we needed more history in constitutional interpretation, more history on the Supreme Court, was to overcome this problem that otherwise the Constitution's meaning would remain uncertain and indeterminate. Second, there was a crisis of constitutional modernity, which I will speak about in a minute. But these are crises that the turn to history attempted to solve or was said to be in the service of solving. But then there are the crises that the turn to history has either caused or deepened. One, the first one, is the crisis of historical distortion, what I call the crisis of historical distortion, and the other being the crisis of interpretive legitimacy that I think the current Supreme Court faces in a particularly acute sense. So my agenda for today is to flesh out these four and the different sort of levels they work on, to invite us to think about how they fit together and how they fit into the larger conversation we've been having about constitutional crisis. And I'd like to do this by way of making a broader argument about history and constitutional interpretation, by suggesting why it is to me that the use of history and constitutional interpretation has been largely misconceived by people who are part of this movement, and why it is that we ought to draw very different lessons from history when we study it in the context of constitutional interpretation. I believe strongly that the study of history can illuminate modern constitutional interpretation, but often not in the ways that people assume. Okay, so to begin with those first two crises, the crises that history was meant to solve, or that originalism was meant to solve. So to start with the crisis of interpretive uncertainty or indeterminacy. So as many people know, originalism emerged in response to the Supreme Court's jurisprudence following the Second World War, where under the Warren and Burger courts, so named for Chief Justices Earl Warren and later Warren Burger, the court dramatically expanded the scope of constitutional rights, particularly in core areas such as civil rights, reproductive rights, and the rights of criminal defendants through several controversial landmark rulings such as Brown versus the Board of Public Education, Griswold v. Connecticut, Miranda v. Arizona, and Roe v. Wade. And while these rulings in the 50s, 60s, 70s, and 80s were celebrated on the political left, they were viciously criticized by political conservatives who complained that the Supreme Court was inventing rights nowhere found in the Constitution. Rather than interpreting the Constitution as they found it, the justices were instead legislating from the bench. They were privileging their own subjective moral values and policy preferences over duly enacted democratic laws. So originalism was devised to counter this supposed judicial activism. Now, the term originalism was not coined until 1980 in a law review article by former dean of my law school at Stanford, Paul Brest, but its key intellectual ingredients were forged in the decades prior. So responding directly to these Warren and Burger Court rulings, early proto-originalists denigrated the idea of a so-called living constitution, which maintained that the Constitution's meaning evolved over time as social values changed. They claimed instead, no, the Constitution's meaning did not evolve over time as society changed. Its meaning was fixed until it was formally amended by the only people with true power to do so, the sovereign people of the United States through Article 5, the formal amendment procedure to the U.S. Constitution. It was certainly not for unelected judges to decide when society had evolved enough and how much and how that reflected itself in constitutional law. What judges ought to do instead, early originalists said, they ought to take the Constitution as they found it and try to understand what the true decision makers, the sovereign people, had originally put there. So that meant focusing on recovering the original intent of the Constitution's framers and going back to that time zero when the Constitution was made, which mostly meant the American founding. The idea was that if judges looked outside of themselves, not what was just or good or moral or decent or what society generally supported, they would have to look to something else. History forced them to look outside of themselves to something else. It would let them, in the words that John Roberts made famous years later, just call balls and strikes. So since those beginnings, a different kind of balls and strikes. Since those beginnings, originalism as an idea has evolved rather dramatically. You need a PhD in originalism these days to stay on top of the sort of dense theoretical forest that originalists have created. More on that later. But no matter these changes, as originalism has grown and shape-shifted in all sorts of different ways, all originalists have shared, I think, a broad aim: to turn to history to make constitutional interpretation more neutral and more objective, to look to the constitutional past to solve this crisis of constitutional indeterminacy. And that crisis, in the eyes of originalists, ran a lot deeper than just the Warren or Burger courts. They were just a pure embodiment of the deeper issue of being semantically unmoored, of not knowing what things meant because they could mean different things to different people. So the threat of unmoored interpretation was longstanding and ubiquitous. Within law, this was the challenge that had long been posed by so-called legal realism, which first reared its head in the early 20th century, where legal realists claimed that law was necessarily more than abstract rules or formalities that judges applied to the fact patterns that came before them. Law was always embedded in political, social, and economic contexts, and that meant that law invariably was shaped by social interests and public policy. As just a matter of what happened, judges necessarily made law as much as they merely interpreted it. Meanwhile, beyond the legal academy, there was the challenge posed by the specter of so-called radical interpretive indeterminacy, which in the second half of the 20th century was sweeping through several corners of intellectual life. There was a rising chorus of philosophers and literary critics and anthropologists and historians of science and many others championing so many isms, postmodernism, post-structuralism, pragmatism, who were very much emphasizing the constructed nature of meaning and interpretation. They were stressing in a lot of different ways that the act of interpretation was inherently generative and creative. It was an activity that molded texts into new shapes as much as it simply captured what authors had put there. There was no God's eye view of the world. Any human interpreter necessarily saw the world from a certain perspective or a certain paradigm. There was no way to climb outside of this. So against these storms of interpretive relativism, originalism promised a formalist stronghold, a formalism that would be rooted in history, that suggested if only we looked backwards to when the law was made, we could return to figuring out what the law was, rather than reveling in the uncertainty of what it could be or should be. Now, to say that this was a sort of dominant motivating force of originalism does not in any way discount originalism's undoubted political origins. The motivations behind originalism were as political as anything its champions sought to displace. It's impossible to understand the rise of originalism and its spread thereafter apart from the political purposes that it was mobilized to achieve. But while that is unquestionably true, and that helps explain originalism's emergence and lasting power, it is also very important to understand that originalism was sold and had success selling itself as a way to take politics out of legal interpretation, to turn judges back into people who didn't make law, who weren't politicians in robes, but were just judges who followed the law. And for many who became originalists, especially in the academy, this promise that it gave a way out of interpretive indeterminacy and uncertainty was not just very attractive, but was the idea that they are still desperately fighting for. So that's the first crisis that originalism was leveraged to solve. The second one, the crisis of constitutional modernity. Well, here I follow my good friend Jack Balkin, who has explained that modernity is the sense of separation from the past. And in the American context, that came on in the 20th century as people began acutely recognizing that the world of the framers, the world of that time zero back in the 18th century, had long since passed away. And as Jack Balkin puts it, this sense of separation from origins created a crisis of constitutional modernity. And as Jack Balkin puts it, and I agree with him, as is true of a lot of religions who face a modernity crisis, there are two standard reactions to this kind of problem of modernity and a loss of organic conception to the past. The first response is to accept that we are modern and embrace our separation from the past. In the context of a constitution, to embrace a living constitution. Nothing wrong with our origins, but that was then, this is now. We go forward, times change. The second response is to cleave to the past as aggressively as you can in an attempt to regain it, or in the space of constitutionalism, to think about originalism. So Jack Balkin thinks about how originalism and living constitutionalism are twins separated at birth, and I think this is very accurate in a lot of ways. Now, most originalists will push back against this and say, no, originalism is anything but modern. It's a very old interpretive approach, maybe the oldest interpretive approach. It has certainly been around since at least the founding. It's the default way to interpret and read legal texts, and it certainly was the dominant way that the US Constitution was interpreted, they argued, from the founding until the early 20th century, when the progressives that Rogers told us about yesterday ruined the world by putting us on a different track, or so originalists will often claim. So this idea that originalism has been around forever, I think, faces several major difficulties. I'll be happy to talk about it at greater length, but one historical, one conceptual that I think fuse together. The historical difficulty is that Americans disagreed as fiercely over how to interpret the Constitution from the founding through the 19th century as at any point in American history. So if they were all originalists, what were they fighting over? John Marshall is an originalist, I've been told. Thomas Jefferson is an originalist, I've been told. There are no two Americans who disagreed more sharply, violently, and bitterly about how to interpret the Constitution than John Marshall and Thomas Jefferson. Their letters say, the way John Marshall interprets the Constitution, his method of interpretation, is horrible. So if those two people can be originalists, then I'm not sure what the category is picking out. What this suggests is they were having different fights on different terms that our modern originalism living constitutional debate doesn't quite capture. And that historical difficulty, I think, points to the conceptual one. Originalism as an ism amounts to far more than stressing, as yes, many people did across the 19th century, sometimes caring about what the framers originally intended. It's more than just an argument you make some of the time or a data point you point to some of the time. It's a comprehensive attitude. It's a belief that the original meaning of the Constitution trumps all other considerations. And what it really is in its 20th century instantiation is a conscious rejection of living constitutionalism. Nobody in the 19th century rejected living constitutionalism because it didn't exist. They were having different kinds of conversations. Originalism defined itself in opposition to this idea that is very much of the 20th century. So originalism as an ism is very much, I think, a product of modern times, a reaction to the crisis of constitutional modernity and what we do with it. It promises a way to maintain touch with our constitutional origins and founding principles, to stabilize our polity during uncertain and shifting times. Modernity has unmoored us. This is a way to reground ourselves. And there's no doubting that this idea of regrounding we, which I put in scare quotes because of so many talks we've heard that show how loaded that concept can be, really helps explain originalism's broader popularity among the American population. If you look at popular originalism, so if you look at Charlton Heston's speeches at the NRA, or if you look at Tea Party rallies, and they're all talking about something like originalism, it's very much a story of who we are, how we've lost connection with who we are, and we should get back to it by regrounding ourselves in our original founding principles. So Reva Siegel, Jamal Green, a whole bunch of scholars have written great work that shows how originalism as a form of constitutional memory and memory politics is extraordinarily important. And it also holds some of the clues to why Americans are originalists in ways that, well, Canadians, Australians, people in the UK are not, which I'd be happy to speak for as well. So that sort of discourse of sort of rerouting who we are is less muted, is more muted in academic settings than on the bench. But a more consensus version of it is nonetheless something that originalists rally around, including my good friend and colleague at Stanford Law School, Michael McConnell, a former federal judge and leading originalist. As he's put it in recent times, in our contentious and polarized times, the text and original understanding of the Constitution take on particular significance because there really is no other consensual starting place. This is what we have to reground ourselves during this particular moment, especially of intense disagreement. So those are among the crises that history was meant to solve. But this turn to history, as I said at the beginning, has caused a crisis of its own, two of which I will stress here. So first, the crisis of historical distortion. By transforming U.S. constitutional interpretation into historical recovery and restoration, originalism promised, as I said, neutral interpretive principles. It could transform subjective questions of value into objective questions of historical fact. Yet in practice, in both theory and practice, originalism has distorted the very past it deems authoritative. And there are two distinct forms that this distortion has taken. First is what can be called the issue of historical selectivity, picking and choosing from available historical evidence in an unprincipled fashion. So this problem plagued originalism from the beginning in its infancy, back when originalists were more focused on what they called recovering the original intent of the Constitution's authors. As numerous critics pointed out right away, well, which authors? The Constitution was written, 55 people were at the Constitutional Convention. It was then sent to the Special Ratifying Convention, 1,700 people were there. There was a much larger public beyond that. James Madison says one thing, Alexander Hamilton says another. Whose intent is determinative here? On top of that, the framers had different expectations for what would follow from enacting this Constitution. They had different original expected application understandings. Which ones did you follow? One person thought this would obviously follow from the Constitution, this one another. And that said nothing of the related problem that many of those expectations, given their views on race, sex, and equality, were pretty morally retrograde. So originalism's most celebrated theoretical shift, the shift from original intent originalism to original public meaning originalism, was made in large measure to try to overcome these difficulties of selectivity. Rather than having to pick and choose among different founding era intents or understandings, originalists now sought to understand simply what the words of the Constitution's text objectively communicated to the public at the time of its enactment. So as Justice Antonin Scalia, who was one of the great leaders of public meaning originalism, says, what I look for in the Constitution is the original meaning of the text, not what the original draftsman intended. The text is law, not what James Madison thought. Or as Randy Barnett, a leading public meaning originalist, has put it, the new originalism, or public meaning originalism, seeks to identify what a reasonable speaker of English would have understood the words of the text to mean at the time of its enactment. They could disaggregate the object of interpretation, the Constitution itself, that communicated information through its words objectively, from all the people who surrounded it, who had different and competing views about what it meant. The problem with this celebrated shift in interpretive focus, though, is that it did very little to address, in my view, the underlying problem. It merely refashioned it, and in ways that remain opaque. For all the talk of hypothetical average readers, public meaning originalists usually can't get very far without looking at concrete constitutional arguments that actual people made in the past. So for all the talk of how different public meaning is from either original intent or original expected application, public meaning originalists can't get very far without looking at things that certainly look like original intent and original expected application. And that's because in most instances that matter, the Constitution's words fail to self-define. So originalist interpreters need to look beyond that bare text to concrete linguistic usage, people actually using the words that are in the Constitution. And in most instances, not only is it the best evidence, but it's sometimes the only evidence of usage of these terms, is found in the concrete debates over framing the Constitution or ratifying the Constitution or the earliest interpretations of the Constitution or the earliest practice that took place under it. So the crucial question becomes not whether originalists and everybody else should look to legislative history or early interpretation and practice, as it turns out everybody always has to, but when certain usages that crop up in these contexts count as public meaning and when they don't. It's a question about when something counts as criteria of evidence and when it doesn't. And what invariably follows is a form of picking and choosing based on uncertain criteria that this shift was supposed to obviate. Sometimes what the framers or ratifiers intended or expected is good evidence of public meaning. And sometimes it's not good evidence of public meaning because it's not public meaning and is therefore dismissed on those terms. So we can consider just a couple examples here that are extremely important, not just in originalist scholarship, but also in current Supreme Court cases, and how this sort of different ways you could code evidence in different ways is used differently across competing examples. So on the one side is the idea of presidential removal power, and the other one is the so-called non-delegation doctrine or the idea that Congress cannot delegate rulemaking authority of a particularly important kind to the executive branch, especially administrative agencies. And what's striking to me here is how many originalist academics and jurists have used founding-era evidence in conflicting ways across these examples. So in the case of presidential removal, the Constitution's text is famously silent on who can remove executive officers. And a lot of originalists think that this power should be vested in the president. And they claim it is vested in the president because Article 2 begins by giving the president the executive power. And an incidental feature of executive power, they argue, is the power of removal. But they prove this by turning to all of the sources that would seem to be outside of public meaning. What is said in the Federalist Papers, or especially the 1789 debate in Congress over presidential removal power, or commentaries by learned jurists like Joseph Story that were written 40 years later. This is good evidence because it's evidence of public meaning. However, when we look at the same Congresses, the same post-ratification people in the case of delegation, as certain people have said, if delegation from Congress to the executive branch is unconstitutional, why did the first Congress, second Congress, third Congress, fourth Congress, and fifth Congress delegate all this rulemaking authority to the executive branch? That evidence is coded differently. Well, that just shows that there's a gap between early practice and original public meaning. That maybe just shows that members of the early Congresses violated the original meaning of the Constitution. This is not evidence of public meaning. This is just something different. It's not public meaning. Or then there's the efforts to deal with early constitutional ambiguity, a big issue. And a lot of originalists have here seized upon the idea of constitutional liquidation that James Madison first laid out in Federalist 37, which was this idea. Madison had a deep understanding of all sorts of different things, but especially how constitutional technology worked. And he said, look, if you write a constitution, what is invariable is that, no human language is perfect enough to capture all subtlety or anticipate everything that will evolve under it. So as a result, all new laws, though penned with the greatest technical skill, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. So there will be parts of the Constitution that are ambiguous, and then you have a series of discussions and adjudications that liquidate its meaning. My wife always finds this confusing because she thinks liquidation means to destroy something, which is what it means outside of law. But in law, it means to settle and to make clear what had previously been unclear. So originalists have latched onto this idea as a way of kind of doing originalism moving forward. Okay, it's time zero, but maybe it's sort of drying cement, right? It takes a little while for things to get sorted out, and it allows us to look more easily at the decades following the Constitution and seeing that as part of the founding moment. But again, we see a sort of split here in prominent examples where there's a kind of liquidation for me but not for thee kind of quality. And here I'll just latch on to the examples of the idea that the federal government's powers are so-called limited and enumerated. The national government of the United States does not have general lawmaking plenary authority. It has powers that are strictly enumerated, and they are limited to that enumerated list. And then the 14th Amendment and civil rights, or the privileges or immunities clause. So when it comes to national power, a lot of the Constitution's leading framers didn't think the powers were limited and enumerated. They thought that the national government, for a variety of reasons that I'm happy to expound upon, had broad powers. If you looked at the preamble, if you looked at other parts of the Constitution, it pointed to how the powers were anything but enumerated. But an argument that is pretty common among originalists is, okay, there were leading framers who thought that, but there was a political struggle in the decade after the Constitution over how much power the national government should have. And Thomas Jefferson's limited government, states' rights, strict construction form won out. That's what the election of 1800 ends up liquidating. And then thereafter, there was a settlement. John Marshall, who leads the Nationalist Supreme Court, he doesn't try to fight Jefferson on this. He says in McCulloch v. Maryland, yes, the powers are limited and enumerated. So we have a 224-year unbroken tradition of limited and enumerated powers. That was liquidated. Well, what happens if we go to the 14th Amendment? Well, if we consider that, many of the 14th Amendment's framers thought that the Privileges or Immunities Clause identified and protected a broad set of fundamental rights, and this is something that a lot of originalists stress. 5 years after the 14th Amendment is ratified in the slaughterhouse cases, the Supreme Court guts the Privileges or Immunities Clause. And every Supreme Court thereafter has continued that interpretation. And this is a pretty dark story. This was the basis by which the Supreme Courts in the 1880s struck down the Civil Rights Acts and basically allowed Jim Crow to take shape. But no meaningful constitutional actors fought them on this. The public didn't think this was wrong. So you might think, is this a different story of liquidation? The Privileges or Immunities Clause has been around for 156 years. For 151 years, authorized constitutional decision makers have had a single interpretation. But we are told that is not liquidation. That is not an unbroken tradition. That is not public opinion through deliberate practice and discussion sorting something out. All that is a story of how the early Supreme Courts violated the original meaning of the Constitution. It's not liquidation, it's betrayal. So to cynics, all of this can feel like heads I win, tails you lose originalism. And fair or not, I think the deeper problem is even a good faith interpreter does not really know what to do when faced with examples like this. So that's the selectivity problem. The other one that dwarfs it, that is much larger, is the problem of historical anachronism. Here the issue is not arbitrarily counting or not counting evidence, but the misreading of historical evidence itself, and particularly misreading it by falsely assuming that it was written in the legible terms of modern constitutional and legal thinking, that people back at the founding thought about constitutionalism like we do today. So too often when I see how originalists talk about the founding, they don't remember a vital lesson captured by L.P. Hartley's famous line, "The past is a foreign country, they do things differently there." Or as Bernard Bailyn, the esteemed historian of the founding era, put it, one of the central problems in the practice of history is the problem of recovering the contexts in which the events take place, the settings, the unspoken assumptions, the perceptual universes of the participants. Now, not all past historical periods are as alien as all others, and there's a lot of times to emphasize similarity rather than difference. But if there's one thing that historical scholarship on the American founding has made clear, it's that people back then thought very differently than we do now, and especially about constitutionalism and law and its constitutive categories like rights and liberty and republican governance and fundamental law, as Stanley Elkins and Eric McKittrick, I think, capture well in this quote. Now, this doesn't necessarily matter for today, but it seems to me it very much matters if your interpretive method is to recover the original meaning laid down in the past. You need to think seriously about what it would mean to recapture that perceptual universe. So in a lot of instances when originalists interpret the original meaning of the Constitution, they assume too much about what they think the key words are saying, but I think the problem of anachronism runs much deeper and wider than just textual meaning. The issue is less that originalists get original meaning wrong than they get the foundation on which original meaning supposedly rests wrong, that foundation that original meaning rests on is itself ahistorical. And this is hard to see because this gets back to what Victoria talked about yesterday, most of the originalism debate is very narrowly focused on specific textual parts of the Constitution. Standard originalist debates usually follow questions like, what did the words executive power mean? What did the words freedom of speech mean? What did the words keep or bear arms mean? It's very focused on a slice of the Constitution. But that focus of zeroing in on a particular set of words tends to take for granted the very thing holding the meaning, the Constitution itself. As Victoria was saying, as Maggie was saying, the Constitution itself as an object is just assumed to be, the Constitution is just the Constitution, the same now, the same as it was then, as it is now. That's not something we have to think very seriously about. But one of the big arguments I'm making in a book that I have forthcoming is that the Constitution was not just the Constitution. If we return to the American founding, we find a very different way of thinking about constitutionalism, and based on that, a very different understanding of the Constitution. So in other words, if we focus on the Constitution itself, we see this opposition between originalist constitutionalism, the set of assumptions about what kind of thing the Constitution is that originalists presuppose, and how people at the founding tended to think about the constitutional object. We find very different answers to these much more fundamental questions. What constitutions were, what determined constitutional content, how constitutions were enforced. This is really where a lot of the anachronism creeps in. And the clearest way to illustrate this, I think, is to think about differences between founding era and modern originalist understandings of written constitutionalism. So again, I'll pick up on things Victoria and Maggie have already nicely teed up here. When people talk about the US Constitution, usually they single out as its single most important attribute that it is written. That's what it is, it's written. And originalists attribute as much significance to this fact as any other. The Constitution is a tangible document. You can carry it around, a copy of it in your pocket. You can go see it in the National Archives. It's written down on a tangible piece of parchment. It has 4 corners. As Michael Paulson has put it, the central feature of the Constitution, the first thing one notices about it, if not a dolt or a mystic, is its writtenness. But what's most important here is what is assumed to follow from this characteristic. Because the Constitution is a written document, that means its content is distinctively textual in nature. To interpret the Constitution is to interpret its language. As Lawrence Solom says here, originalism is a thesis about the meaning of the text of the Constitution, the text as it was written in ink on sheets of parchment at a particular place in time. This is why so many originalists, such as Justice Scalia and now Justice Gorsuch, have likened originalism to textualism and likened the Constitution to a statute. The Constitution is basically like a statute, and you interpret it through textualist principles. So they jump from the fact that the Constitution happens to be written to a very robust conception of the kind of thing it is, that it's alike in kind to a legal statute. By virtue of being such a text, the Constitution is presumed to automatically provide an account of its own content and communication. The Constitution acquires content through text, and then it communicates that content through text. Interpretation runs through the text because the Constitution is the text. And if you had any dispute about this, the founders, we're told, thought the same thing. They thought that's what the constitutions were. Well, revolutionary Americans indeed wrote their constitutions, but their understanding of what followed from that fact was worlds apart. So contrary to modern originalists, they did not believe, I argue, that writing constitutional principles down automatically or necessarily altered their legal status, transformed constitutional content into linguistic content, or erected sharp textual boundaries between what was in and thus outside of a constitution. And there were many reasons why. To begin, it's important to understand that at the founding, constitutions consisted of many distinct features, some of which were fixed through textual codification, and some of which were not. So founding Americans often used the word constitution in ways that would be surprising to us. They used the word constitution often to describe the constitution of government, or the form of government, by which they meant the literal structure of the government. Other things we think are constitutional, like bills of rights, they often said weren't part of the Constitution. You had a Bill of Rights and a constitution or form of government. So this was, how many executives do you have? How many legislative assemblies do you have? What are the rules by which people get elected to those? How long are term limits? These are set features of the constitution of government. And these features of constitutions at the founding era were indeed usually fixed through text. There was no other way to know how many presidents there were in the United States other than to look at the text and say, there is one, and here are the rules by which that person gets into office and serves. But there was more to fundamental law, a lot more to fundamental law than just the form of government. There were also the powers delegated to that government and the rights retained by members of the political community. And each of these were often grounded in forms of fundamental law that preceded or stood apart from enacted constitutional text, that instead derived from how law and constitutionalism were understood to work. So in broad strokes, at the founding, it was believed that law was as much found as made. Law was not simply what authorized legal institutions had enacted. It was also those general principles of law that were identifiable through reason and practice. Now, often they called these principles natural law, but the key, I think, to understanding their legal thinking is that they had an integrated view of fundamental law, of law in general, one that assumed that different sources of law naturally harmonized. So they thought about law without a lot of the distinctions that modern legal thinkers take for granted between positive law and non-positive law, between law and morality, between reason and consent. They thought the boundaries between different kinds of law, the law of nations, common law, municipal law, natural law, were necessarily porous. They bled into each other. They made a unified, integrated whole, and the job of the legal theorist was to understand how that works. So just consider the common law. In realist terms today, the common law is regarded as judge-made law. That's what the common law is. It's the decisions of courts that judges have made. But in the 18th century, it had a much broader set of meanings. It was a way of thinking about law more than it was a body of law, and it helped harmonize what were otherwise what we might think of as competing sources of law. So the common law was predicated on custom, long practice and acquiescence, what people had done and put up with for lots and long time. That was taken to be the best marker of popular consent. What do the people want? What have they done for 2 centuries? But at the same time, the common law was regarded as the perfection of reason. The common law helped reveal, through long practice, a more general set of legal principles that had nothing to do with the people's willful consent. So the common law was at once the contingent law of a particular community, how we do things here, and was also the best way of understanding how law worked generally across all communities. It was the principles that transcended. So by fusing custom, consent, and reason, the common law could be understood as contingent yet timeless, changing based on circumstance and need while remaining constant over time. And this is completely, radically different than anything Justice Antonin Scalia ever said the common law was. So the founding generation took an integrated view of law that helped them identify general principles of law, and those general principles of law that were deemed most fundamental encompassed what could be called general fundamental law. This was a conception of fundamental law that fused what was written with what was unwritten, what people had consciously made with what was necessitated by reason. As Joseph's story here, just one of hundreds of quotes you can find from the founding era describing this. We think ourselves standing upon the principles of natural justice, upon the fundamental laws of every free government, upon the spirit and letter of the Constitution of the United States. A modern legal thinker would want to break these down into different sources of law. Story, like most people at the time, was trying to understand how they harmonized and fused. So this account of general fundamental law has profound implications for how the founding generation thought about the nature of written constitutional content. Constitutions were at once the fundamental law that was created through textual enactment, and it was also the fundamental law that people left in place. So written constitutions effectuated, elaborated on, and harmonized with general principles of fundamental law. Just look at this quote from John Quincy Adams from 1791. "The Constitution of a country is not the paper or parchment upon which the compact is written. It is the system of fundamental laws by which the people have consented to be governed and of which the written or printed copies are nothing more than the evidence." A perfect example of this in the Constitutional Convention. They're talking about, should we expressly enumerate a prohibition on ex post facto laws? And we've got these 2 very illiterate legal thinkers, only 2 of the first justices appointed to the United States Supreme Court, James Wilson and Oliver Ellsworth, saying, not only would it be a bad idea if we put this in, it would be embarrassing. Because if we tell people that we're prohibiting ex post facto laws, which are always already illegal, we will be announcing ourselves ignorant of how general principles of law work. So what Wilson and Ellsworth are saying here make no sense if the only constitutional content of the United States will be what is written into the Constitution. You better have a prohibition on ex post facto laws if you want that to have constitutional status. Here, Wilson and Ellsworth are saying it's already in our Constitution. That's among those essential principles of law we're going to leave in place. So in addition to that, how they thought about fundamental law, every bit as important, the founding generation understood constitutions specifically within the framework of social contract theory. So social contract theory was a thought experiment about how people left the state of nature and set up legitimate government. And the key here is just there are 2 steps. This was really important at the time. First, you left the state of nature and formed a social compact. You form a we. You form a polity, a political community. Step 2, you draw up a constitution of government. But what this meant is when the founding generation talked about constitutionalism, every community had 2 constitutions. the Constitution of the Social Compact and the Constitution of Government that sat on top of it. And you could not interpret this one unless you first interpreted the one that was beneath it. And that was how they understood rights and powers. So when it came to rights, most fundamental rights were understood to be protected in Constitution 1, the Social Compact. That's why only about half of the original state constitutions had declarations of rights. That's why there was no Bill of Rights in the original federal constitution. And that's why when rights were added in what we now call the Bill of Rights, as George Nicholas and many others said, it's fine to add these, but let's make it very clear that this is a declaratory statement. We're not creating constitutional rights. We're merely offering textual reminder of rights that already exist. And it was the same thing with powers. How much power did the federal government have? Today, that question is, what does the text of the Constitution say? What are the different powers and what they add up to? Generally, back at the founding, what they said is, to understand that, you have to understand the social compact of the United States. Is it a nation? Is it a confederacy of sovereign states? Is it something in between? What is the preamble saying when it says, we the people of the United States? That will tell you whether or not the national government, even though the written Constitution is identical, whether the national government has a lot of power to see to the general welfare or considerably less power. So in short here, just because the original US Constitution was written doesn't mean that it communicated in the ways that originalists often assume. This usually means that they engage, in my view, in a form of historical ventriloquism, speaking through the founders rather than listening to them. And rather than taking the past as they find it, they turn it into something it never was, which is the exact thing they were against. So lastly, and very briefly, this crisis of historical distortion has fueled a crisis of interpretive legitimacy. The sense that the Supreme Court is distorting rather than following history is among the reasons why the public approval of the court is the lowest it has been in decades. This legitimacy crisis is the result of what happens when a political and ideological movement claims to champion an apolitical and non-ideological solution to political and ideological division. And here we can see the different forms of originalism have been pulling at one another. With judicial originalism struggling to accommodate the competing pressures of political originalism, what the movement wants in terms of results, and intellectual originalism, which was always based around this idea that this apolitical method would determine the results, not a preconceived agenda. The court has tried to overcome this crisis by turning to history more and more, but that has only deepened and intensified the culture wars. But what I want to end with is the idea that that failure is less one of execution than outlook. Trying to overcome the problem of constitutional indeterminacy and conflict through a method of constitutional interpretation is unlikely to work. A constitutional system that is fraying demands institutional, not interpretive solutions. The question should be changed, I think, or could be profitably changed from how should we interpret the Constitution to who should be doing the interpreting. And here I think history has more positive lessons to offer. Three things I'll just quickly end with. If we turn to the Constitution's history and take it very seriously, rather than finding ultimate answers at time zero to our modern constitutional questions, I think we instead learn three things. One, the Constitution's history emphasizes above all its avowedly historical character. It's not surprising that the US Constitution is, in crucial respects, indeterminate and invites fundamental dispute. It always was thus. Unlike other interpretive objects, it was a political instrument born of political compromise and disagreement that was built to channel political and legal life indefinitely into the future. Unsurprisingly, it emerged in the world unclear and not fully formed at time zero, and it was only made into something more concrete through practice and debate. So there's this feature of the Constitution. We make the Constitution by arguing over it and appealing to it, the very appeals that it is supposed to regulate. Originalism is a hope of getting out of that cycle. I think what the failure there is not appreciating why the cycle is inherent and is not a bad thing. That is the kind of constitutional system in decision-making that is consistent with a pluralist democracy. So what that should then second have us do is transform our thinking from seeing history as a command back into a resource, to see history as a source, as a guide of edification, not a set of final answers to today's predicaments. Seeing all the ways in which history doesn't neatly speak to the present and will force us to make decisions on other grounds breeds a sense of humility that is useful. We can draw different lessons from the founding rather than that one. And among the lessons we might draw, if we might ask ourselves, if there was one thing that really set founding era constitutionalism apart from modern constitutionalism, it was the idea that judges have unique authority over the Constitution. Nothing would have baffled the founding generation more. Judges on the Supreme Court have almost unchecked authority over the constitutional order? What? All the major constitutional controversies of the first years of the Republic, every single one, not one of them went to court. Nobody filed a lawsuit. Nobody thought the courts would do anything, the most important of which was the fight over Alexander Hamilton's National Bank and chartering it. It was a fight in Congress. Congress voted for it. Then it was a fight in the executive branch with different members of Washington's cabinet telling him to veto or not. And as Thomas Jefferson said, this is the decision, your veto decision. Because the idea there will be some other decision, we will lose the fight in Congress and the presidency and then send a lawsuit to federal court, never would have occurred to anybody. As Thomas Jefferson says, if we're going to allow judges as the ultimate arbiters of our constitutional questions, that's a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. James Wilson said the Constitution is an ordinance and establishment of the people, and I think that's the historical question to return to. What does it mean to remain faithful to that idea? Thank you.
And microphones being circulated. So we have about half an hour. I will only humbly suggest and remind you of the interrogative character of a good question, so try to keep it short and clear so our speaker can answer directly.
I'm sorry, I don't know how to operate this.
It's working.
It's working?
Yep.
Okay. All this talk about history, entitlement of history, is a deja vu to me, because right now there is another country that claims entitlement to history. On the South China Sea, since the beginning of history, South China Sea, the 9-dash line is always China. Taiwan is always China. Okay? So my question is, do you think, what is happening in the U.S. debates about, constitutionalism is destroying the American image abroad, saying that we are rule of law, equal right, or whatever, it's just a hypocrisy. And you may not be aware of it, the Chinese is studying very closely. Is that the last time the U.S. has a constitutional crisis, okay, is settled by civil war. And they even calculate the U.S. lost 12% of its population in the Civil War. So for China to stop the secession, we have to learn from the American history. It doesn't matter, he said, you said, she said, is the rule of law is equals to the rule by law, the rule of might. So all we have to is to prepare 1.6 billion people die, doesn't matter, okay? We just have to build up a fleet and all this FONOP and those things. America is not even a part of the UNCLOS and never rectified. So this is the image abroad, So I'm saying that, do you think that all this debate has an international implication as well? Thank you.
Yeah, thank you for the question. It clearly has an impact. It's bound up with a lot of different things, but I think it's also important to think about two things that I mentioned. So one is, why are Americans originalists? Other countries have written constitutions and judiciaries and interpret them, and don't instinctively make these kinds of arguments, at least not to the same degree, or a great number of scholars have. So they could be. Yeah. But a broader sense of history is shared by most nations, which is, to get back to what Robert was talking about in the last panel, how you create we's and the narratives that sustain them. And part of what's important with originalism is it has an academic component, a judicial component, a political component that fit together and draw common stock from different kinds of streams. And there's a particular way of understanding how history bears on legal interpretation of legal texts, and then there's a way of understanding how history establishes sort of honored authority, national ethos, and a sense of what was before the fall. And in that regard, I think it's very connected.
Yeah, Jonathan, that was terrific. Lou Pauley, political science. Let me go down the same road, but a little bit more directly to to the themes that have come up at least throughout the day, and back to Roger's last point in the last intervention in the last session. How far can we go with your line of thinking in responding to this tension that he put on the left between now, the sense of the nation, and all of your talk actually was essentially bounded by an internal American, a long-standing historical debate. But now it's quite clear that in the terms that it seems quite clear in the terms that you put at the end, at least part of the body politic is reconceiving itself in a much more open context. And that is very difficult in the context of the crisis of modernity. Let me just put a fine point on this. A couple of years before Scalia died, I was invited by a friend at AEI, first time conference. Scalia was a speaker, and then he took most of the people at the conference over to the dining room behind the Supreme Court, where the justices are allowed to use every once in a while. And he came in, actually, to convene the dinner with a Roman Catholic priest, I'm a Catholic, a Roman Catholic priest in a hammock, in a hassock from the 1950s to lead the grace, which was like a search for certainty in both the church and the court in an era when certainty is impossible. So you knew at the moment that was just a cry of despair in many ways, which a lot of our institutions are living through. So it's quite legitimate, to go back to Roger's point, that most of us in this room are reconceiving our identity in more global terms without losing our sense of the nation, which takes you back to some kind of federalist sensibility, basically, even maybe a confederalist sensibility. How far can we use your reasoning to justify that position?
I think you could use it to justify it to a great degree. You could also push it in very different directions. Well, so one might be, I recently reread Louis Menand's The Metaphysical Club, talking about how Oliver Wendell Holmes and the pragmatists were attracted to a form of philosophy that was anti-dogmatism, that took very seriously things that now get disparaged as postmodernism, but in their point, it was not about emphasizing the impossibility of knowing anything or certainty, but about recognizing the extraordinary violence that certitude had caused in the American Civil War. And in Oliver Wendell Holmes's sense, this was not having certainty in the space of legal interpretation, or as he would always say, tell me the outcome and I'll use whatever method, any of your favorite methods on the court to get there, and I'll show you how to do it. And he didn't just mean it as there's no there. He meant that's precisely why this is not mathematics. They're not axioms that you then apply to fact patterns. They're bounded up, they're entangled, and the job is to understand why there's still a there, to better understand the there, and it's more suitable for democracy. That an effort to kind of climb outside of that uncertainty, different people will have different views of things, can be seen as an anti-democratic impulse. So one thing I tend to emphasize in my scholarship is, yes, there wasn't certainty about what the Constitution was, let alone what it meant in 1787. What's wrong with that? So then a democratic community of we the people had to create it and then continue to create it and go through all the struggles and fights that are constitutive of that, while in the process constantly appealing to the very thing they're fighting over as the arbiter of what they're doing. But that's not necessarily different than what we do in any democratic space. I mean, it's not like scientists walk in on climate policy and tell people that, there is what you do in the lab, and then there's how you make certain kinds of public statements about truth, give them democratic force and authority. And that's the history of democracy. So, originalists will often say, Scalia famously said, he always said it when he did his two-man show on the road with Stephen Breyer. He said it was the bear method. If Breyer and I come upon an angry bear in the woods, I don't have to outrun the bear, I just have to outrun Breyer. So if originalism's so bad and terrible, what's the alternative? You need an alternative. And I think this is another example of begging the question, because I'd say, no, the alternative is what we've done from the beginning, which is a form of constitutional pluralism, which is sometimes looking to text, sometimes precedent, sometimes doctrine, sometimes original intent, sometimes longstanding practice, having different doctrinal categories and understandings and presidential power as opposed to individual rights, separate, and that's what we've done. And maybe that's bad, but that's what we've done. And so tell me why we should throw that out and replace it, not with history, because we've always taken history seriously as a data point, as a source of edification, but as the thing. Because today, what makes Gorsuch and Thomas originalists, they are very much originalists, is they're self-identified members of a movement. But they're not originalists in terms of their jurisprudence. They're pluralists, no different than Elena Kagan and Ketanji Brown Jackson. They talk about history when it's convenient, and they like it. They don't talk about it when it's not. And they, Trump v. Anderson, consequences. I never, the first case that bore on history where consequences were relevant, as though the other ones there weren't consequences. Suddenly consequentialism matters in judicial decision-making. So I think that's an alternative story to tell.
Hi. I guess I would have two questions for those who are self-declared originalists. How many of them believe that the original writers of the 13th, 14th, and 15th Amendments prioritize the rights and privileges of corporations over those of people? And how many of them would then remove the constitutional basis based on the 14th Amendment that corporations have all those rights?
I'm trying to think of the many originalist academics I spend time with, many of whom I count as good friends, who I don't feel have weighed in a lot on this subject. Obviously, the jurists have made it very clear what they think. I think a lot of them would say that they would agree generally with Citizens United about an understanding of speech and the rights of corporations being captured under the First and the 14th Amendment. I think many of them would say that.
Yes, but that's not originalist, right?
To go to the 14th Amendment?
Yeah, writers of the 14th Amendment didn't
Oh,
care about people's
well,
beings, not corporations.
well, so this gets to public meaning originalism versus original intent. You separate, Connor and I write something down, and then we throw it out into the world, and 5 years later, what does it mean? You can either walk over to this room and say, tell us what it, and we don't want to know what you think now. Do you have emails from 5 years ago? We want to see those. But some people say, who cares what they thought? They have no claim over it. So that becomes very convenient when you have strong historical evidence, the strongest of which, this was one way to understand originalism is the problem of originalism for a while as racial politics in the United States changed was it could not get to the right answer on Brown v. Board of Education, which is the most iconic, important decision in American constitutional history, and many people think is the ultimate litmus test. The ruling that found that segregated public schools were unconstitutional is our moral touchstone. So any theory that can't reach the right answer on that is dead. Now, Scalia often complained this is waving the bloody shirt of Brown. You can't judge an interpretive theory by one case, but he knew that was a political loser, so an enormous amount of effort was poured into the intellectual exercise of justifying Brown on originalist grounds. Well, how do you justify that the framers of the 14th Amendment in 1866, or the ratifiers in 1868, intended for public schools to be desegregated under the 14th Amendment? That's pretty hard to do when the same Congress that wrote the 14th Amendment segregated the one public school system in the District of Columbia that they had custody over. So you have to separate the meaning of the amendment from the intent of its framers or what they expected to follow. Because they could have written all those things in. They could have written privileges or immunities of citizenship accepting school segregation, but they didn't. So now, if the problem with originalism is how do you get to the right answer on Brown, some people say the new problem of originalism is once you get to the right answer on Brown, what can't you get to? So part of what I was trying to expose there is this is still a debate over meaning versus intent, when I think the real debate is over how we use evidence to establish constitutional meaning, and so little time is spent on that a lot of jurists and academics can be thick or thin as they want to. If you kind of like the substantive constitutional views you find in the past, you show how those make the meaning. You can't really like the view of the average Reconstruction ratifier, because those were all white men, and they definitely did not want social mixing. They were promised that the Reconstruction amendments would not lead to that.
I'm going to exercise my prerogative as moderator and jump in here, because I think it gets at some of your framing as well, with the discrepancy, making your distinctions along the way between originalism as an academic phenomenon, a judicial phenomenon, and a political phenomenon. And the question is the problem originalism, or is the problem the judges? And in part, it's motivated by two things that you got to. One is that originalism has always been a moving target, and just constant reform. It's its own living, constitutionalism in that sense. But also, there's the refrain always when there's some criticism is, much like Marxism, real originalism hasn't been practiced yet.
Yes.
The next version, the next symposium,
It's never been tried.
Right, the next version that comes out, the next update to corpus linguistics will solve it, which suggests that there's an intermediary between the history that you do and the practice of judges. Is there some utopia that once we get the history right, we defer to the historical experts here, or is it how do you kind of puzzle through the distribution of burden there between originalism as an enterprise and then the judging role?
Yeah, so it's a great question, and gets to the heart of so much. How do we think about what even is the Constitution? What even is originalism? And what is it drawing its main source from? And part of the problem is that even if you can separate them, they're all connected. I mean, this is the one ism the Academy has created that is a resounding success story. Rush Limbaugh's listeners didn't know what law and economics was. They don't really know what originalism is, but they're willing to fight to the death believing in it. So that's a powerful idea. So it's important to recognize the cross-fertilization, that even if academics are saying, don't judge us by what Ted Cruz says on the campaign trail, what he is saying, what he's tapping into is part of how their ideas continue to have purchase, and then the Federalist Society and the bench exist in between as sort of key mediators. In terms of the broader question, what I'm trying to get to is the what I was hoping to sort of emphasize at the end is the solution here is not historians on the Supreme Court. The solution is understanding that in a great many ways, because the past is a foreign country, constitutionalism in law was different, like so many other things. In some ways, it stayed similar. In some ways, it's changed. So as a result, in a great many instances, the past is not neatly speaking to the present. If we want to apply the past to the present, we have to engage in some form of translation, which requires discretion and judgment and a whole variety of things. And that's hard to do if you've established that, well, this is the law, this is the answer, this was what was sent down. What we should instead be saying is, okay, we have these laws on the books, certain regulations on concealed carry of firearms in New York City. So one way to look at this is to return to time zero and say, what does the text of the Second Amendment say? What kind of regulations were or were not deeply rooted in the nation's historical traditions? A different way would say, okay, what does the history, that original history, have to teach us? And in what ways is it just speaking at cross purposes? And not hide behind the idea of, well, the founders made us do it, and instead own decision-making and say, we have decided that in an ultimate balancing test in a republic between what governments must do for the public good and what we think is important for individual rights, we think the balance test should work like this, but that's not, The Warren Court and other courts that followed were trying to come up with balance tests. Scalia and other originalists said, we don't need balance tests. The founders did that for us in the text of the amendments, which is part of the reason it's important that the text of the Bill of Rights was declaratory and not, Scalia just, that very premise, the text created a right and created a balancing test, is as unoriginalist as anything you could find. The thought at the time was the text identifies a pre-existing right in the social compact, which is broad and underdetermined. A right to free speech has no legal criteria. That doesn't tell you exactly what you can or cannot say or what legal rules will determine that. Same thing with the right to keep and bear arms. The people who will determine those legal determinations are the people themselves. This is what popular constitutionalists thought in the early republic, through the institutions that speak best for the people, legislatures and juries, and only judges to the extent that they could be fairly being said to apply the common law understood as the people's customs broadly construed. So that idea that the right is fixed, pretext, and then its specifications and details worked out over time by the people's representatives, the actual original balancing test, is the precise thing that originalism has destroyed on the bench.
Do I correctly read in your excellent presentation that the constitutional debate in the US has become religious, as the originalists using textualism, as literalists use the scriptures without context or spirit, you know? And problem I find there is that the originalists only go back to the Constitution 250 years ago. But whereas in the non-democratic republics of, for example, China or Russia or Iran, the Constitution is only a working document going back to earlier constitutions of Confucius and Christianity and Islam. What my question to you is that in only going to the Constitution of 1776, do you not think that the originalists have met more than match in the Christian right who want to go to earlier sources of Christianity and John Locke?
That's a great question, because that is certainly an emerging fight in the conservative legal movement about whether to even be originalists as opposed to Catholic integralists or common good constitutionalists, or to just appropriate originalism as common good originalism or the like. So there's different ways to think about this. So, I mean, the first thing you sort of hit on about people always compare originalism and its textualism to biblical literalism. But a very striking, so again, get back to why are Americans originalists? It's always had a very popular evangelical Christian streak that this kind of way of reading authoritative texts translates nicely into. But very strange fact is the public leaders of originalism on the Supreme Court are overwhelmingly Catholic, which proposes a very different way of reading authoritative text. So that's an interesting wrinkle. But that is a big part of why originalism is found in America. Part of it, too, is the recent founding and only having the founding, or at least only having the founding in terms of the story we tell ourselves, not having a sense of ethnicity or blood or peoplehood or religion. What unites Americans is a creed found in creedal texts. So a lot of people have made this argument, and that makes something like originalism far more potent, because American identity is bound up in the Constitution itself. Now, to your sort of broader question about where this might be going, I mean, one of the interesting things about the early salvos in that fight among constitutional conservatives was some of them said, we need to stop worshiping these non-religious, deist, slave-holding patriarchs at the founding, and should instead, abandon the liberal tradition, which includes John Locke. John Locke's a liberal. We're conservatives, they said. We need to find real conservatives. So they started telling a different story about the founding of America that was based on Lord Baltimore and the founding of Maryland. And, well, that didn't work, because that's not actually what the audience really wants to hear. So what they've ended up doing is a different version, which is to say, actually, if you go back to the founding, you find robust governance, right? So there's a libertarian streak on the right, which is more Jeffersonian, small government, a lot of federalism, limited and enumerated powers, don't have a power to broadly regulate the national economy, don't have a power to mandate people purchase health insurance, things like this. A different kind of conservatism in the sort of top left corner of the 2x2 matrix is much more open to robust governance and finds a lot of things at the founding they like, because there was an extraordinary amount of governance at the founding, and some of it was about public safety and health and regulation, a lot of it was, but a lot of it was also anti-blasphemy laws, religion, religious constraints, laws on what you could say, and they find a lot they like there. So you're starting to see a fight then over the history, and then some of those people use some of my work that tries to point out the more robust views of the founding. They weren't anti-government. They just were having debates over which government would be very robust, the state government or the general government. But that, some people have interpreted that Dobbs held the center, that the revolt was stopped because it showed the Supreme Court was on their side, and both libertarian originalists and big government moral social conservatives can claim they both have won. But I don't think we know where that's going.
We have just a couple minutes left, but I anticipate the next two questions being good. So I want to make sure I get both of them, and then you can respond
Great.
As you will. So, okay, yeah.
Hi, John. A couple of quick questions about history. I was wondering if you could maybe, and maybe now there's not enough time, reflect a little bit on the politics of knowledge and disciplinarity as, so what is being sort of looked to as history? What kind of proof is considered persuasive? So how is that happening? And then I was also curious about what you think this moment in the sun might be doing to our discipline. If we're all originalists, are we all now historians? And how do, the obvious politics of the American Academy right now sort of condition how folks are responding to this call for history, but it's not being directed at you or us, right?
Great questions. You want to do both at once?
Yeah, do you want to, Ryan?
Oh, sure. Too much pressure. This question's going to be terrible. But I guess I want to ask what let's say we accept all your arguments as true. It's very convincing, most of it. What does it actually cash out as in terms of how it affects constitutional discourse? I think you can make the argument that it resolves exactly no constitutional questions, because there's no question that supposedly rhetorically addressed on originalist grounds that couldn't be addressed in another way. And then another problem with your argument is you have to get back to, okay, where did originalism come from? Well, I think you'd have to say it's not just Scalia. There's Hugo Black. There are the New Deal justices who developed an idea of textualism, very flawed, but it emerged for some pretty significant reasons. So I'm just wondering what are your thoughts about the problems of judicial overreach? Living constitutionalism, it's a great symbol, but like a lot of great symbols, it means let's stop thinking now, right? It's a real problem, right? What prevents living constitutionalism from being seat-of-the-pants policy analysts, right? Another way of putting it, if you don't like conservative originalists now, wait till you see the conservative non-originalists coming down the pike, right? Isn't that not a possibility?
Well, the counter to that would be there'd be no difference just in level of honesty and rhetoric. Fair questions. Yeah, great. So I'll start with yours and then go to Kevin.
Okay.
So, yes, there's much more to be said. Before modern originalists, no Supreme Court used history more than the Warren Court, which is a great irony, right? And the reason why is if there are laws on the books and precedents you don't like and you want to change them, history has an extraordinary power to serve as a trump card. So there were a variety of reasons why. So it's more complicated, and Jack Balkin's argument is more complicated, and I think he's generally right about how there's sort of the living constitutionalist idea of that was then, this is now, let's go forward. The originalist one we need to get back. But in both cases, they also saw themselves as trying to change the law, right? So there are different ways in which they're actually drawing from both streams, and the Warren Court did this a lot. Not very good history, often quite poor history. So there is a deeper story there, but I think it is connected to the 20th century emerging self-consciousness of what do we do now with a government and a constitution that don't quite, and a society that don't quite match up. And I think you can fit Hugo Black and the Warren Court into that story in a similar sort of way. I ended with this because I think that's the best answer to your last question. We don't need a different Supreme Court, and we don't need a Supreme Court that interprets it with a different method. We need a court that doesn't have so much power. I don't think you can have, ultimately, a healthy republic with so many policy questions effectively being outsourced to the Supreme Court. That wasn't true at the founding or the 19th century. Most major constitutional decisions were made by the political branches. The court had a much smaller footprint. They tended to actually do the things laid out in Article 3. They sort of, cases and controversies arising under federal law. Now, I'm not saying that's simple, because as Victoria was talking about, the Warren Court rights revolution and other things, I mean, there's a bipartisan project of how this happened. But I'm not sure that method of any kind will be the solution, because what constrains the justices has always been other things. It's not been some sense of text or history, and whether that's living constitutionalists or not, it's a sense of public opinion. It's a sense of what other justices think of them and whether or not it will be respectable. So I think institutional solutions are the only way to think through this, and the debate has been so problematic because since the 1960s it's been a debate over how should judges interpret the Constitution. To get back to Victoria, the question should be, how should the Constitution be interpreted, and by who, and in what ways, in what contexts? And that's a broader conversation. So to close out with this question, yes, Catherine. So I constantly face the struggle of whether I should get involved with certain amicus brief writing based on a lot of things I say here, because arguments that will be most conversant and legible can often be ahistorical. So one's about partisan gerrymandering. There are great arguments for why partisan gerrymandering is bad at the founding. They have to do with things that, like the Republican Guarantee Clause, that used to really, really matter, but is now non-judiciable. But absolutely, that's what people at the founding in the 19th century would. They talked about the Republican Guarantee Clause all the time, what it meant to guarantee a Republican form of government. They would say, I don't know if Wisconsin has a Republican form of government if the Democratic Party can win 63% of the statewide popular vote and not win a majority in the State House. But that wasn't going to fly with Anthony Kennedy. He needed a First Amendment argument, which was obviously going to be ludicrous. So I sort of struggled with that about, you know, there's the practical question before us about what might persuade a fifth justice and what is our job as historians. So what I try to do generally is I think history works really well to debunk constitutional arguments that other people are making. So they're making a strong argument, and then you can show, as historians show well, the messiness, the complexity, the contingency, the difference, and therefore why that argument shouldn't be the reason why this federal regulation comes down or the administrative state comes down. I think historians have gotten into trouble when they flip that script and, you know, like the infamous abortion brief where they just kind of ignored Susan B. Anthony and the suffragettes, kind of deeply anti-abortion attitudes, and the Heritage Foundation had a field day. I don't think that's good. That's terrible for our discipline. Our discipline should be rooted to a certain understanding of what we do and its integrity, and that can work really well in this space. But if we sort of get drunk on the idea of responding to the moment, then it also has the effect of undercutting whatever authority there might be, which is not a simple thing to navigate, but I think is omnipresent.
Thank you for that. Please join me in thanking Jonathan. And it's my turn to thank you and everyone. I have no big grand wrap-up other than to say I hope we return to where we started, seeing constitutional crisis, maybe not differently or at least in a new light, maybe thinking more clearly about it, and that you see the value of thinking seriously about it from all of these different angles that we have. I know I'll be thinking about this for a long time, so I just wanted to quickly, in closing, thank all the sponsors, CSUS, the Department of Political Science, the Monk School, Ron Herschel through his professorship. Their support was wonderful. To thank all the presenters and speakers who came. You can tell that they came just for this conference. That's why many of them had to leave, but they took time out of their busy schedule. So thank you for all the time that it took to prepare to be here. We've been honored by your presence. And finally, to everyone who came, some of you who stayed through everything. I see my students. I see you. Thank you. Enjoy the rest of the day. Enjoy the weather that Toronto has for you. So again, thank you.